Hello, everyone. I'm Phil Brandt, President and CEO of AIM Employers Association, and welcome to This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode. It's Thursday, November 7th, episode 303. Today, now that most of the votes have been tallied, it's time to look ahead at what the results mean for employers. Join us for a deep dive into the anticipated shifts in labor and employment law based on the 2024 election results, and discover proactive strategies to keep your organization ready for change. Don't miss this chance to prepare your team for the road ahead. This show is brought to you by AIM Employers Association, live every Thursday morning, so you can regularly connect with their experts and get your legal questions addressed by Ogletree Deacons. And now, it's time for This Week at Work.
Oh, good morning, Bert. We got a lot to talk about. How are you this morning?
I'm doing well, Phil. I'm a little tired, have a little election hangover from a couple nights ago.
I tell you, it is. I find that to be an extremely exciting night. I stay glued to the TV. I'm surfing channels. I love the process of, declaring a state a victory before 1% of the votes are in. That's just amazing to me. There's no chance, right? And the accuracy of that as well often is really quite impressive statistically how they do that.
Yeah, I might differ from you a little bit. I don't love it as much as you do. I don't like the gamification or the game showification of the election process. I feel like I'm watching like Sporting Bet or NFL Red Zone or something.
It does have that feel. You're right.
I don't
really
don't
does.
love that because of how serious it all is. I am very pleased, however, that when we actually got results basically on the night of the election.
That
isn't
I agree.
lingering. Yeah,
I agree. When it's lingering, I mean, we still have things lingering here in the state of Missouri, which is quite interesting as well. But yes, I like to be able to go to bed and know that the world has found its balance, whatever that might be, and that we're going to move forward. But yeah, let's try and keep it light. Bert, let me ask you. Let's vote on something else here since we've been voting a lot lately. Gravy
sure.
or no gravy?
That's a tough question. I don't know. I mean, there's nothing light about gravy, Phil, but I'm probably leaning toward gravy.
Yeah, gravy 2-0. That's the lead right now because I'm with you. I'm all about the gravy. Smother it on the turkey and mashed potatoes. And I know Thanksgiving is right around the corner, so I'm definitely into the gravy for Thanksgiving. But
Phil, I'm gonna be right back. I guess it really if I had to say, I would have to give you that answer because it really kind of depends on how well the turkey is prepared, though, because if it's dry, it definitely needs the gravy. If it's not so dry, then maybe not. I don't know.
Yeah. Well, if you're having dry turkey, you need to talk to the cook.
Yeah, absolutely.
All right? Yeah. All right. Well, let's introduce our poll question here today. How should employers respond if political discussions are impacting team morale? Slightly twist on that question. I know there's still a lot of discussion afterwards. Some people are excited. Some people are not as happy. There are lots of things in your local state and or county that can be controversial. So how should you respond if it's impacting team morale? Love to have your comments and thoughts on that. As always, we'll address anything that you put into the chat box as well. That's one of our favorite things to do. Bert, are you ready for Lawyer on the Clock?
I am ready, Phil. Lots to talk about today.
All right, Nick, pull that lever.
All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
This week, I talked about a really interesting ballot measure up in the state of Massachusetts, and I want to follow up on that one. So on Tuesday, voters in Massachusetts gave Uber and Lyft drivers a very novel way to unionize. And it's definitely, I can say this will definitely head to the court system. I think there will also be legislative efforts to rein in this law. The ballot measure basically allows Uber and Lyft drivers and other gig economy workers to unionize, even though they are independent contractors. So they're not employees, so it doesn't come within the ambit of the National Labor Relations Act, at least not as I understand it. And so I don't know that there will be challenges to this law under the National Labor Relations Act. I would have to really dig in and look at that and get creative. I think that more likely what you're going to see is challenges in the state court system in Massachusetts. Union advocates had really made an aggressive push for this legislation. It's the first of its kind in the country, and it creates a state supervised process for drivers of ride hailing services to organize, unionize, negotiate their wages, benefits, and other terms and conditions of employment while still being independent contractors. Most states had tried to go after the independent contractor model and try to make the employees of the Ubers and Lyft, try to make the workers of Ubers and Lyfts employees, which would give them a right to organize. This allows them to remain independent contractors, but have the right to organize. So,
so Bert, let me just ask a few questions on this. So the National Labor Relations Act doesn't necessarily cover this, but they voted a law to say that an independent contractor may unionize. But the unionization that we think of in our country falls under the National Labor Relations Act. So this is kind of outside that system of the National Labor Relations Act. I would expect that the Labor Act would say, well, you can unionize, but you have to determine what does that mean and how do your rules work, because this is how the National Labor Relations Act rules work, and they are not part of what you just voted on.
Yeah, so the National Labor Relations Act applies to employees, non-managerial, right, non-supervisory employees. This law is different because it allows unionization of independent contractors, sort of in a sector. So this is like sector organizing, which is, like you said, very similar to what you might see in unions. I mean, in Europe. And so it's a really remarkable mechanism that this law contains. It requires unions only to win 5% support from active drivers from a ride-hailing platform for the state to provide contact information for all the active drivers. And then once they do that, then they only need to win 25% of the active drivers to be certified as those drivers' bargaining representative. Very, very different from the National Labor Relations Act rules, where it takes basically 50% plus one of the people who actually vote in the election to win. This is 25%.
Wow. You talk about, now when I think about labor unions and so forth, and you think about unions are about fairness and voting and majority. That's what I think of as one of the things that was a foundation of, American labor unions when they started, majority. And here they're saying, oh, no, throw this majority thing out because it doesn't really apply to, we don't want majority to apply to us. We only want 25% to apply to us. Yeah, that's quite interesting.
So that's going to definitely be litigated, because what happens to those other 75% of the union members, or the Uber and Lyft drivers who might not want to be represented? And just so to put it in perspective here, this basically means that nearly 100,000 rideshare drivers in Massachusetts may be forced into union ranks. And so it's going to be, I'm definitely going to be keeping my eyes on this one.
Yeah, that's a really good one. Hey, I just, Bert, I mean, it's a good day. I know you're feeling good about some of the election results and so forth. And I just want to point out something from our friend Dave in the chat here. Not too often does Dave throw you a compliment.
Oh boy, I haven't seen it.
and I'm looking at the chat here, and he says, Bert is right about the turkey. So you and Dave have found some common ground to build from there. So Dave, there you go. Look at it. It depends. Burt Garland.
A gift from my friend Phil Brandt
Yeah, I love it. It's
and
I hope it
AIM.
keeps your coffee warm. And I just say good morning to Ginger. She's always following the program. She works up in Illinois, and she thinks that training education is, the way to go to improve respectful communications, not just on the issue of politics, but other things. And I couldn't agree more with you, Ginger. I hope I see you next week at the roundtable as well. She always shows up. All right, Bert, I'm sorry. I'm taken away from the program here.
That's all right, Phil. So another one, and I'm just going to touch this on the surface, but with Trump taking the White House, the Republicans firmly in charge in the Senate and likely in the House of Representatives as well. I do expect to see some pretty sweeping changes at the federal administrative agencies for purposes of our program, really kind of focusing on the EEOC, the Department of Labor, and the NLRB. And again, just touching on the surface. Keep in mind that Trump will not get control of either the EEOC or the NLRB till about 1 to 1.5 years into his presidency because of the staggered expiration terms of the members. So at the EEOC, there are 5 commissioners. Those staggered terms will create a situation where Trump really won't get full control of the EEOC until about 1 to 1.5 years into his presidency. Similarly, the National Labor Relations Board, there are 5 board members. The expiration of those terms means that he won't get full control of the NLRB until about 1.5 years into his presidency as well. And this is no different than when Biden took over from Trump. It took about a year or so, 6 months, I think, at the NLRB and maybe a year at the EEOC for Biden to get control. Maybe I have them backwards, but these staggered terms, it's nothing unusual. But I do think it will limit the ability of Trump to make massive changes immediately. But I do think over the course of his presidency, changes will be coming. The one I do anticipate may be taken up at the congressional level is I do think that the Congress will be focused on at least attempting to try to rein in employers' DE&I efforts. So keep that one on the radar at the department. So that's would directly impact the EEOC. The Department of Labor, I think that you will see the department itself backing away from trying to classify independent contractors as employees. And I think you will also see them backing away from trying to classify employers and staffing agencies as joint employers. And again, I'm just touching the surface here. I also think you'll see not as great of an effort to pursue minimum wage increases or salary threshold increases. I do think that this makes it probably more likely than not that the January 1 salary threshold increase that is supposed to go into effect may not go into effect. I think this tips the scales a little bit. The mechanism for increasing this next minimum wage looked like the one proposed during the Obama administration, which was struck down by the court system. If this gets struck down, you could expect that Trump's DOL would not appeal the striking down of that. So we will definitely have to keep our eyes on that one. And then the one that I'm a little less certain about is the National Labor Relations Board. I think this is really interesting because there are many unions and more importantly, many union members who helped push Trump to victory this time. And so I think that
look at some of those swing states, and we're going to take a look at that here in a minute, but he got a lot of support for some union members.
He did, and even unions by not endorsing Harris helped Trump, and there are unions that actually did endorse Trump. And so it's going to be really interesting to see because I'm just not so sure that the Trump administration, I think you will see him reining in things like joint employer, and I think you'll see his administration reining in things like employment policies, not making them so onerous on employers. But as far as union organizing goes, I'm not so sure that the administration will make a big push to try to switch the organizing mechanism that's in place. Now, the one thing I do think that'll happen is that there was a decision or procedural rule that went into effect at the NLRB, sort of flipping the organizing process on its head. We've talked about it many times on the program. I do see that one getting changed back to the way it used to be. But other than that, I think the timeframes for unions to file petitions and the date of the election, I think those are likely to remain, somewhat consistent moving forward. So, but there is one thing I can assure you will happen at the NLRB.
All right, here it comes. I've heard you talk about this one several times. Yeah.
Yes. So, when Biden got into office, basically on day one of his administration, he told the general counsel of the NLRB at the time, Trump's general counsel of the NLRB, Peter Robb, to resign immediately, even though he still had plenty of time left in his term. And when Peter Robb said he wasn't going to resign, he got fired. It was literally on day 1 or 2 of the Biden administration. Just recently, within the last couple months, we've talked about it on the program here, a court upheld Biden's authority to terminate Peter Robb as the general counsel of the NLRB, said that was a lawful exercise of power by the President of the United States. Well, the current general counsel of the NLRB, her name is Jennifer Abruzzo, and she has been really quite an activist general counsel of the NLRB, going after things such as non-compete agreements, non-solicitations, confidentiality agreements. And I do see that stuff getting reined back in under the Trump administration. I guess I would say that on day 1 of the Trump administration, I expect Jennifer Abruzzo to be fired.
Yeah. Well, I just gotta have some. I expect that will happen very early in his control and decision making process. But I just is there anyone else you can think of that Biden fired?
Not offhand.
No, me either. I'm
Yeah.
like, I mean, the one person he picked to fire was Peter Robb.
Yeah.
That I know for sure. Find that
Yeah.
interesting.
I'm,
All right.
I'm sure
Anything
there
else?
were others. Yeah, just kind of on the
maybe.
lighter side. I always like to find one of these cases to end on the lighter side here, Phil. I've had some litigation over the course of my career. I think the oldest lawsuit I've ever dealt with, it took about 7 years from the date of the employment decision until the lawsuit got wrapped up. I've got nothing on this case. And this is still going on. A New York federal judge just rejected a bid from the U.S. Equal Employment Opportunity Commission and an iron workers union to resolve a 53-year-old lawsuit.
Oh my goodness.
Yes. Dragged on forever.
Yeah.
Yes.
That's,
the case involved Iron Workers Local 580's treatment of Black and Hispanic members, saying that basically that the union was disproportionately assigning working hours for Black and Latino members. The case was filed back in 1971, and there's been some consent decrees. Back in 1978, in the 1980s, the union was held in contempt for not following it. The union and the EEOC told the court that recently things have improved in the decades since the last consent decree, but the judge rejected the unions and the EEOC's attempt to resolve this litigation, and so 53 years and the case is still going. I mean, I would seriously doubt that any of those attorneys who originally filed that case on behalf of members who were with the unions at the time, none of them are probably still around. But the case continues.
Yeah, that is quite a case. That must be close to a record. I don't know.
I would think it has to be.
Yeah. All right, Bert. We're getting some questions in our chat line. I'd want to make sure that we get to anything else on.
Nope, that's it.
Lawyer on the clock. All right. Well, I think most of our conversation is still going to center around the legal side of things today, but I do want to bring up one one segment just out of Filbert's forum, real quick before we move on and have some discussion about the results and the questions that we're getting centered around some of the changes in the Missouri minimum wage overtime, or not overtime, paid time off ruling. But I find this one quite interesting. Nick, maybe you can pull up Gwyneth Paltrow for us here, the photo of a newly elected mayor coming from Rabbit Hash, Kentucky. So it's a famously elected the dog Gwyneth Paltrow as mayor. So you can see we haven't completely lost our minds. It says here a little bit that there have been other towns that have elected goats, cats, and even mules. Plenty of jackasses have been voted as mayor in ceremonial elections to raise funds for fun. So hopefully they raise some good money and it goes to a good cause out in Rabbit Hash, Kentucky. Ever been to Rabbit Hash, Kentucky, Bert?
Nope, and never even heard of it until today,
Yeah, I
Phil.
think it sits along the Ohio River up northern Kentucky border there, I believe. I've never been there, but I think that's where it sits.
Yep.
All right, Bert, let's get into some of these election results that we've seen and talk a little bit about them. And then let's get on to what it means for those listeners in the state of Missouri that have some changes to make relatively quickly as the time for timeline to make these changes is very short, really. But we had some very close swing state results. I know most of our listeners have looked at these, but when I look at these results, I look at this and I'm like, when people say their vote doesn't matter, holy cow, the vote matters here, does it not?
Yeah, that is for sure.
I mean, you look at Pennsylvania, Nevada, Georgia, North Carolina, Michigan, Wisconsin, Arizona, all in very, very tight margins. And when you mentioned, if you were a union representative and you didn't vote because you didn't want to give Trump your vote, but by not voting, it definitely impacted the results as well.
Yeah. Really interesting to see what happened across all the so-called swing states, and the electoral college, kind of a landslide in the electoral college, and even some consider that to be a landslide at the popular vote. Just again, I think all of the pundits on TV can cover that a lot better than we can. But yeah, really an interesting times in the country.
All right. One of the other things we chatted about last week was Amendment 3 in Florida was the adult personal use of marijuana that was on the ballot. And it needed 60% to pass. I believe that was for their constitutional change. It needed 60%, and they got 55.9%. So it did not pass. They did get the majority of people to say yes, but it didn't pass with enough strength to change the Constitution there. So adult use marijuana in the state of Florida did not pass. But they still, I believe, have medical use of marijuana available should that be needed. Anything you want to add to that, Bert?
Nope, I think you covered that one, Phil.
All right. And then Missouri
No,
Proposition.
no right to weed in Florida.
No right to weed, unless you're medically
Unless
necessary.
it's medical, yes.
Right, that's right.
Yeah.
All right, so let's talk a little bit about the Proposition A, which was to raise the minimum wage and requires paid sick leave for employers. You want to kick that off and talk about what that means and what we might want to be thinking about? And I think you probably have seen Christina's question, which is, when calculating the new sick leave law, would we consider sick, vacation, holiday, and overtime pay?
Yeah, so on really specific questions, I'm going to have to deal with those on a one by one basis, because they're we will be
So
getting
new
some.
too as well.
Yeah, we will be getting some material out on that. So let's talk about the minimum wage piece first. So right now, the minimum wage in Missouri is $12.30 per hour. And basically what the new law is going to do is it's going to increase the minimum wage in two stages here. It's going to 1375 next year on January 1, 2025. So get ready for that. And again, we also have the looming, as I mentioned before, increase in the salary basis threshold test under the under
FLSA.
DOL. Yep, the Department of Labor at the federal level. And again, that one I'm not so sure is going to go into effect, but lots for HR to do between now and the end of the year. And it's also open season, as I like to call it, for benefits these days. So
Right.
HR is going to be busy the rest of the year. And then in 2026, January 1, 2026, the minimum wage is going to increase to $15 per hour. That's the
I like
easy
how that
part
was
of the law.
worded. Just a side note, in the ballot said, it'll go 1375 goes into effect January 2024, and then what?
2025.
Or 25, I'm sorry. And then they said $1.50 per hour or whatever the jump was every year thereafter until 2026.
Right.
It's
Yeah,
like
exactly.
I was like, that's really interesting wording, but
Yeah.
I'm digress. Go ahead.
Yeah. All right, but then what a lot of people didn't realize was part of this legislation, and I know we inform people on our program about this, Phil, but a lot of people didn't realize that as part of this legislation, that Missouri was implementing paid sick leave. And basically, under this piece of the legislation, businesses with 15 or fewer employees are going to be required to provide at least 5 paid sick days per year. And those with 15 employees, more than 15 employees, have to offer at least 7 paid sick days annually. Employees can use this leave for their own illnesses or to care for family members. The earned sick time will begin to accrue at the commencement of employment or on May 1, 2024, whichever is later. So that means that we do have some time to get interpretations of this law. So we will have some ability to make sure we're prepared for the implementation or the effective date of this law, which again is not until May 1, 2024. I'm sorry,
2025.
2025. Well, wait, hold on. Earned sick time began. Oh, I'm sorry, the accrual of the sick time. See, I'm gonna have to look at this much more closely, Phil. I'm looking at some notes here, and I think that date might be off on the notes I'm looking at here. Up to 80 hours of earned paid sick time can be carried over to the following year if unused. It doesn't mean that they will have to be
Right.
carried over. Not all of those. It says up to 80 can be carried over to the following year. And the leave can be used for physical illness, injury, health conditions, and need for medical diagnosis, treatment by a mental health or physical illness, injury or health condition, or for preventative medical care. So now, importantly, it does not apply to individuals engaging in volunteer work for educational, charitable, religious, or nonprofit organizations. And there are a few other exclusions, but by and large, most employers in the state of Missouri are going to have to provide some form of paid sick leave to employees. And we're really going to have to take a look at this in detail to see how existing employer policies on vacation, PTO, sick time will apply to meet the law's new requirements.
Yeah. Now, if I remember, and I know you and the resources there at Ogletree and the AIM resources here are digging in as well to get some clarity on this so we can bring it to our member base and our listeners of this program. But if I do remember, this does apply to part-time. That's one of the questions that is frequently asked. Is it does also apply to part-time workers?
Yeah, that is correct. There's
Right.
a pro rata calculation that is part of this.
Yeah, and I think that's the bigger impact because a lot of times our policies exclude part-time workers, and for that group of employers that have restaurants and staff that is not traditionally full-time and so forth, that becomes much different for them to comply with.
That's right. And I did just check my better notes on this. So basically, under this new law, paid sick time accrues at the rate of 1 hour for every 30 hours
30.
worked. It
Yeah.
begins accruing for existing employees on May 1, 2025, just to make it clear, or the first day of employment for employers hired after that date. So again, we have some time to analyze this, and basically 6 months to get ready for the implementation or the effective date of this law.
Yeah. And I mean, the good news is on this, particularly for those in the local region here in the Midwest who have had employees in Illinois, our mind's already shifted in many ways how to accommodate, and our policies, how to consolidate in them and so forth. So with that, we will bring you more information coming up in the next couple of weeks through this program or special programs to help you accommodate that. So stay tuned for that. Bert, I appreciate the insight. I know you got to go off to a client meeting, so thank you very much for being part of the program. We will be back here next week at 7:30 Central Time. Until then, go out and let's be good to somebody. Bye-bye.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues, forward our invites, share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.